Good evening, everybody. Keith here. We're going to hang out and let some people get on. In the meantime, I hope everybody's enjoying their day, living life, loving life. I don't know what the deal is here, but we're going to just keep hanging out. Tonight we're going to talk about the motor vehicle operator leases. Gonna do some inviting here and see if we can get some people on and hopefully do some talking here. And hopefully some people will do some sharing because I think this is important that we figure out this motor vehicle lease and what to do about it. And so first I want to start out with Title 26 of the United States Code is actually the Internal Revenue Code, the IRC, and relates directly to the IRS. And this is where we see in the United States Code, the federal statutes, is where we see the motor vehicle operator lease. And within those statutes, it's under the IRS code. Why? Well, when we look at the definition of commerce within the IRS code, it tells us that commerce means transportation, traffic, or trade. So in relation to the U.S. codes, they're talking about the transportation codes. In relations to your state statutes, they're talking about the traffic codes. And of course, they're talking about trade. Now, in the motor vehicle operator's lease, we'll talk about that. It says trade or business, and we'll discuss that briefly. But when it comes directly related to the operator's lease, the states are running their state statutes under federal guidelines. Now, those federal guidelines come from the United States codes. Now, if the United States Code held the motor vehicles operator's lease in the transportation code, it might be different. But we see it in the Internal Revenue Code, Title 26 of the United States Code, rather than the transportation code. What that tells us is that it's important to look at that definition of commerce in relation to that it means transportation, traffic, or trade, because it's what the other statutes are all using in regards to its enforcement of the requirement of a motor vehicle operator lease. And I'll explain that to you because it all has to do with the birth certificate, the certificate of live birth, which together is the dual citizen of the 14th Amendment. Okay? The birth certificate is a United States citizen. The certificate of live birth is the state citizen. The state citizen is a transmitting utility for the birth certificate, and it's done under international trade because it's how the U.S. uses the Admiralty maritime jurisdiction to bring trade into the landlocked states that don't have a maritime jurisdiction, an Admiralty jurisdiction. They don't have a naval force. Okay? What this does is it prevents international traders from coming inland, committing piracy, and then going back to their admiralty jurisdiction and saying, blah, nah, you can't get to me. This gives us the avenue to access admiralty maritime jurisdiction as landlocked states. That's what all this is doing. When we think about that in consideration to the motor vehicle operator's lease, under Title 26 of the United States Code, and I've got it printed up there, look at that and read that. And you'll see where it says the certification is where you registered to use your property that you pledged to the state. This is how that whole thing reads. You, in fact, when you registered your automobile, you pledged it to the state, and it says so right in there, to be used at least 50% of its use as a motor vehicle in the business of the for trade or business of the lessee. So, along with all of that, you also have to provide a separate statement stating that, and that is your intent. Now, if I'd have known that, let alone even signed something like that knowingly, it would have most definitely been in error, because there is no way I'm going to spend 50% of my time of using my own private automobile as a conveyance of a motor vehicle to conduct the trade or business of somebody else without being compensated. Now, this is the reason they have commercial driver's license. And these are valid driver's license because they have time logs. They have that separate statement. They have the employment application stating that they are going to be driving. Okay? Now, in relation to the driving, when we think about the employment application, I want to remind everybody to think about that Social Security account, which is the state representative, authorized representative of the state citizen, of the COLB, Certificate of Live Birth, which is on a general account as a pass-through for the birth certificate account, and you are only holder of a branch account of the Federal Reserve, and you are classified by application of the Social Security Administration as a Medicare qualified government employee. So when you signed that application, it was not disclosed to you that you were signing an employment application. And then when you signed a driver's license as a Medicare qualified government employee already, presumably, you are now signing as a government employee to use your private automobile for government business. And that's how it all works. Now, if you look in that lease section, you'll see where it clarifies in the section D of part 2 there, lessor must not have knowledge or must not know that certification is false. And all you have to do is give them notice and knowledge that the certification is false. Who do you give notice and knowledge? Well, it's noticed in the IRC for the IRS, so you would technically give it to the commissioner of the IRS. Notify him that the requirement that you now need is to verify that the certification is false. Does the state have any record that you signed a separate agreement agreeing to your intent of pledging so, as it states in the lease agreement, and that you did so knowingly and intentionally under the registration to do so? If you didn't, then it's false. If they have no time logs proving that you're doing it at least 50% of the time, it's false. If they don't have any record of receipts showing that you are performing in a public capacity and not in a consumer capacity, they have no proof. It's false. If they have no proof that you intended to do so intentionally, knowingly, and willingly, it's false. And they have no records of any of that. They don't keep records of any of that. Under a residential driver's license, they don't keep records. Neither do you. Do you go around? Do you have that statement? And then do you have it attached to the time logs stating that you conducted this business affair in the interest of the public and it cost this much or you spent this much? You don't. Neither does the state. No Teal record. No such record. Period. Now, however, you have record. You have a verified notification. I hope you people understand when you send these notifications, you send them certified copies of your original in affidavit form as a private document through a certified mailing process or a private service. Somebody that will get on the stand and verify that they were given notice and knowledge under the Uniform Commercial Code. They're operating commercially. They can only tax commerce. So the IRS has to operate commercially. Under the UCC 1-202, notice and knowledge. They have been given notice and knowledge that the certification of the automobile registration for use as a motor vehicle under a motor vehicle operator's lease known as a driver's license, a state driver's license. The U.S. doesn't require a driver's license. It only defines what a motor vehicle is. Again, it doesn't have a motor vehicle operator lease in it. The states may, but they're dependent upon the IRS code where it defines motor vehicle operator leases. Understand that. Again, IRS again defines commerce as transportation, traffic, or trade. So again, in that operator's lease, they say in the lessee's trade or business. Understand what trade means. In reference to trade or business, that's not one word, that's not two words, that's three words put together and it's a term. Look up the term trade or business and find out what trade or business means. It's none of their business. You have a right to private association. And unless they can clarify that you're let me explain to you again about that Social Security account. Okay, they're classifying you as a Medicare qualified government employee. Under an employment application, there's a doctrine known as the clawback clause. In other words, employment applications are understood, presumed, assumed, implied to have written in them some sort of clawback clause, where, in other words, you can go back to a certain time and restore what should be right. And that's the basic concept. The basic concept about the Social Security account in my research and my intent is to simply get back what I paid in consideration and not be required to take upon the systems or the Social Security Administration's regulated supposed benefit that is actually detrimental. Unless operated appropriately, that Social Security account is detrimental. Now, I do know that there's information out there that says, and it's under, I believe it's, don't quote me on this yet. I'll look it up and see if I can find it. Code of Federal Regulations, Title 32.310.2 or something like that. And it talks it now I lost my train of thought trying to figure out what code that was. It talks. Oh God, let me. Well, it talks about being able to go back and fix a record that is inherently wrong to begin with. And if we're going to do that, we have to fix the record in the knowledge that the Social Security account being classified as a Medicare qualified government employee is an insurance account. And in fact, through the Treasury Direct account is where you get your exemption. That's what the Social Security account number is. You convert it to a exemption identification number without the dashes. You turn that card over. You've got the Federal Reserve routing number, and then you convert that to a exemption account number, and that is your exemption process on one side of the books. The TDA has record of the minor account that when you go in and you clarify age of majority and customize that minor account to an adult account so that you have direct access through the Social Security as a branch member of the Federal Reserve, your offset, your discharge occurs automatically by operation of law. It's all contained within the Federal Reserve Act in regards to the Judiciary Act, the Savings to Suitors Clause, the Social Security Act. The Clearfield Doctrine clearly points out the powers, and when they start acting in a corporate capacity, they are now reduced no longer to have the judiciary powers, but it clarifies Title 28 USC 3002 Section 15. It used to say, and they've changed the wording. It used to say, and this clarifies it pretty well, the United States is a federal corporation and not a government, including the judicial procedural section, not the judicial power section, the judicial procedural section. So what we have is two Congresses, one with judicial power and one that asserts judicial power through a judicial procedure for its commercial venues. And that's the difference. And that's why that 14th Amendment citizen plays such an important part. It's a private citizen of the United States, which contains a state citizen under the United States as a pass-through utility, protecting the United States citizen. And you are being set, presumed, assumed, and implied to be the authorized representative. And you do so every time you sign anything, and the proof is when you sign the back of that, or the front of that Social Security card with your signature. From that point on, every signature is conveyed, particularly when you use that Social Security account, which is directly related to the driver's license. They use the certificate of live birth for the form of identification. You cannot use a birth certificate as a form of identification. You can use a certificate of live birth because it is a known entity. It is identifiable and identified as a person. And you are known as the authorized representative. And again, you sign the driver's license as authorized representative. But again, this is where it's important to know the UCC as well. Because again, in the UCC, I'm going to tell you, UCC 3-402, subsection B, part 1, clarifies that the authorized representative is not liable on the instrument that he signs as authorized signature for the person named in the instrument. And that's why it's so important to learn the words that they're throwing out there, and it's important to give them notice and knowledge. First of all, I'd like to clarify the certification is false, and as previously presumed, assumed, and implied, and standing on and for the record through every bank check I've ever signed, it clearly states on there, right after it says signature, it says in all capital letters repeatedly, authorized signature. If I'm presumed, assumed, and implied to be the authorized signatory every time I signed a bank check, and it's directly related to the Social Security account, so we just got to think about this stuff and realize how easy it is to defeat their presumptions, assumptions, and implications. All we got to do is give our notice and knowledge. And like I said, I can do that on the record without having to write documents. But if you're going to write documents, know where to send them. Like I said, in this particular instance, the motor vehicle operator leases are defined in the IRC, Title 26 of the United States Code. The United States Code is implemented under the United States Department of State. They're the ones that deal with the consular affairs, foreign affairs. And so when it comes to the United States Code, on one side, in regards to the corporate issue, they have to deal with it in regards to people like myself who are separating ourselves from that corporate jurisdiction and declaring our birthrights. And under that birthright, they have no jurisdiction. Everything is false. All certifications, all registrations, all licenses, all fees, fines, penalties, taxes, things like that are false. The only thing that we pay for is under the doctrine of necessity. When we use those Federal Reserve notes, we do so in our private capacities as consumers purchasing private goods, private family household goods. That was my intent when I went down and bought that roll of toilet paper, just like it was my intent when I went out and bought that automobile from an automobile salesman who was working at an automobile dealership, who had all kinds of automobiles on his lot that were produced and sent from an automobile dealership. And there's only one document that they put out that says it's a manufacturer certificate of origin that then tries to define it as a motor vehicle. Yet again, under the commercial code, UCC 9-102, it clarifies that the use of what one has in possession defines its what it is, defines it. Its use is what defines it. So if I'm not going to use it for trade or business, then the certification is false. If I don't intend to use it for trade or business, it's false. If I don't intend to use it at least 50% of its use, is false. If I don't have record, if no one has record of it, it's very likely there comes a presumption of doubt on the record as to whether it's true. Therefore, can a guy be found guilty? No till record. There's no such record that a lease that a valid lease exists, because there's no statement saying that he intended to do so, let alone a statement at all. So really think about this stuff and understand it. It's that simple. It's that simple. They don't have any records. And if they did, they'd be able to assert it and show you exactly where they get their authority. They'd be able to rebut where I'm telling you where to get the authority and what to do about it. And they can't say it's unlawful. They can't say it's paper terrorism. They're telling you right there in the code, unless the lessor or the lessor must not know that the certification is false. And all you're doing is letting them know that the certification is false per your intent, per failure to provide any record that there is a valid statement under penalty of perjury that I intended to do so. If so, please bring it forward. That would be the contract. Please bring forward that contract. They're not doing this. They're telling you that, well, you signed a driver's license. Well, that's not the contract. The contract is the certification is false. because under the certification, there's also supposed to be a separate statement. If there's not a separate statement, sorry, but I only remember giving one signature. Think about this stuff, people. Anyway, if it wasn't for you guys, I wouldn't be doing this. If you have any questions, please post them. I'll be glad to answer. Please save this post. This is very self-explanatory. You can use it in any traffic citation affidavit. In my opinion, in my firm belief, and done properly through proper notices and everything, you can rebut this and stand your ground. If that driver's license is false because the motor vehicle operator lease is dependent upon that separate statement proving the lease, as well as other documentation of time logs and receipts showing purchases or selling bills of lading for buying and selling goods as a person, which is what a person is authorized to do, is to buy and sell goods. So, as a consumer, I'm buying private goods for my own private intent. But to buy and sell goods for trade or business, it's a different story. So understand this stuff, people, and that's why it's all commercialized and taxed. When he was speaking about changing the record with the Social Security Association, it has to be done through the post office. Can you explain that? Everybody welcome Sean Lane. Sean Lane's a good buddy of mine. This guy knows what he's talking about. When it comes to fixing the record with the Social Security Administration, he's correct. It has to be done through the post office. Why? Because we have to assert our own jurisdiction. We can't be doing it through their venue and assert our jurisdiction. We have to assert our jurisdiction by doing an international port. Otherwise, we're just using internal ports. We're using internal transportation. We're not using international trade. He's very correct. Again, that's what I said. You gotta fix all these words. And again, like when I explained earlier, when the federal government was established, it was established because it's got a contract on the international sale of goods under Admiralty Maritime, and it's got transportation codes so it can transport jurisdiction inland for the sale and trade of goods to the landlocked states that otherwise don't have access to that jurisdiction. Okay? So now the landlocked states have that jurisdiction, but they also the laws be uniform throughout all jurisdictions. That also means that no matter what their state statutes are, and it's clarified that they abide by international law. So they have to abide by the higher jurisdictions, no matter what kind of statutes they're trying to apply. No matter what kind of jurisdiction they're trying to hold you to. So that's why we have to assert our jurisdiction, but we have to do it through the right ports. And again, if you think back, I did a video, Sean, I don't know if you remember watching this or saw it, but myself, I did a video. I wished I had been able to get my brother on to do it with me. He's the one that turned me on to this. But we can use the exemption account itself to make our own homemade postage stamps. Now, granted, it has to be constructed in a certain manner. You don't use envelopes. You don't use their envelopes. You construct them with your own seal in a trifold fashion. And you'll have to go back. I'll send you the video. But we prove that it works. It goes to the United States Postal Service as part of the United States Post Office, and they run it through their meter, and they stamp their meter on it, showing that it's been through the post office as part of the Postal Service, and it's all homemade stamps. So it's clear, and there is no clarification of U.S. code or the UPU or nothing. It's just homemade stamps, and they recognize that well enough. It goes through. And you can ask Danny Laval and Eddie Alexander Banks. They do the same thing now. And we're trying to get this passed around and let people understand you can use that exemption to create your own homemade stamps too. And so, again, back to what Sean was saying, it's very important to understand we need to use the United States Post Office to transfer our notices. They're the ones that are keeping record. They're the ones that are keeping the international record of transporting from one jurisdiction to another an instrument or a document, a vessel. And that's part of the construction of the things that we use for homemade stamps. The construction of it is to the T, the construction of a vessel. So think about this stuff, and I'll post that video to your messenger, Sean, so you can watch that. I think it was back January 19th or something of this year. Maybe sooner than that, but yes. See, the post office, when it comes to the post office, this is the federal government side and you can relate it to the word office. They're the ones that are given an official seat in government to conduct the affairs in good faith. The United States Postal Service are the people of the corporation that office then contracted with to perform certain duties under them, which is the service duties. They perform the regulatory duties, the power duties, and the Postal Service performs the procedural duties. Think about this stuff and realize and understand. Again, I'll point out, since I mentioned that there with the Post Office and Post Service, Title 28 of the United States Code, Section 3002, subsection 15, used to say, and clarified it very well, the United States is a federal corporation and not a government, including the judicial procedural section. And what we need to read from that is that it's not the judicial power section. They're just asserting judicial power by using a judicial procedure. They're using that federal judicial procedure and implying the same power. It doesn't have that power. It only has commercial venue power within their own jurisdiction, under the UCC, under the USC, under the state statutes, under the county codes, under the city municipal ordinances. And they're all supposed to be uniform throughout the jurisdictions, abiding the international law. And that's why we have to use the International Postal Office. United States Post Office. That has an international contract. Period. Anyway, that's enough for now. I'll get that sent to you, Sean. God bless. If it weren't for you guys, I wouldn't be doing this. Love you. Have a great night. Bye.